Good morning. Are you Kavan Sonye?
Yes, ma'am.
And Mr. Sonye, you're charged in cause number 25 DCCR 1530 with a first-degree felony offense of aggravated assault with a family member. And that's from September 28th of 2025. And what that means is that if you go to trial and you're found guilty, the range of punishment would be a minimum 5 years up to 99 years or life in prison. Do you understand? And I have here on the tablet a plea bargain rejection that you've signed with Mr. Burbank. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty or a 20-year term in prison. You have every right to reject that offer, have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. And do you understand all of that? And do you want to reject that offer and have your case set for trial? And I did make the adjustment on the plea bargain rejection from a second to a first that he's been admonished. Is there any reason to believe that that offer would change?
No, Your Honor. I know there's some questions with the complainant that he's aware of because he talks to her on the phone all the time, but the state's offer's not changing.
Okay. So you're talking to her on the phone from jail? Okay. So I'm ordering today that you are not allowed to have any contact or communication at all with Delaney. Is it Sance? Okay. You cannot talk to her. You can't call her. You can't send her letters. You can't send messages through anyone else, period. Do you understand?
Yes, ma'am.
If you're caught doing that, things are just going to get worse. Okay. All that information will be information that a jury can hear or I can hear. Mr. Nichols will hear it. So I'm ordering you now that you are not allowed to do that. If we catch you doing that at the jail, I can order that you have no telephone and none of those things. Do you understand? Okay. All right. Go back with the bailiff. Case set for trial.
Thank you, Your Honor.
Okay.
Good morning. Are you Kevin Thomas?
Yes, ma'am.
And Mr. Thomas, in cause number 26 DCCR 0798, you're charged with a third-degree felony offense and assault on a security officer from March 17th of 2026. Your indictment alleges that you were previously convicted of possession of a controlled substance, a third-degree felony, August 28th of 2000. And then after that was final, you were convicted of burglary of a habitation, second degree, September 29th of 2008. And then after that was final, you were convicted of possession of a controlled substance, a third-degree felony, March 30th of 2021. 2 cases of possession of a controlled substance on that day. And what that means, sir, is that if you go to trial in this case and you're found guilty, the range of punishment would be that of a habitual offender, which means it would be a minimum 25 years in prison up to 99 years of life. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that you've signed with Ms. Holmes that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty to go on, it looks like maybe count 1 and count 2 to make this a second degree for a 15-year term in prison. You have every right to reject that offer. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Mr. Coleman, is there any reason to believe that offer would change?
Not at all, Judge. And in full disclosure, while the 15 years is a formal offer, I did make a today only offer for less than the 15 if the defendant was amenable to that, and he's rejected that as well.
And what was that for?
I believe 10.
Yeah.
10.
So you understand if you wanted to enter a plea of guilty today, there's an offer that was extended today for 10 years. Obviously that's going to be off the table, as will be the 15 after today. Do you understand?
Yes, ma'am.
All right, so we'll get your case set on the trial docket. Mr. Thomas, Ms. Holmes has been appointed to represent you. She's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release her and we can appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, so Ms. Holmes, you'll be released. Mr. Thomas, we will appoint someone today. They should be out to see you very soon to begin preparation for trial. All right, you can go back with the bailiff.
Thank you.
All right, sir, are you Dalton Batiste?
Yes, ma'am.
And this is cause number 25 DCCR 1436. Mr. Batiste is charged with manslaughter. 25 DCCR 1437 charged with manslaughter, and 24 DCCR 07 charged with possession of marijuana. The cases are set for trial to begin with jury selection next Monday. And what is the announcement?
Couple issues, if I may, Judge. Mr. Coleman and I have talked extensively, not only this morning, but in the last lead up to today, and there has been a new proposal put in front of us that I think we'd like to ask for at least a little bit longer than today to consider. I know that also Mr. Coleman has responsibilities to folks on his side to discuss it. Or like this. Sorry.
Take a break. Why is this one? This one's not showing up on my. What is it? It's not on my.
Actually, Angel has his trying to be at felony. He was being very difficult. But now it says Tom Kelly, so that's why we
Oh,
because I had changed their co-counsel and he was trying, I thought he was signing them out. Wanted to make him really turn.
okay.
Couldn't walk the tablet.
And then
You okay? You need some water?
I've got, you want cough drop?
Oh, I do have that.
I think the sinus is the best.
Yeah. Yeah.
No, it's fine. Well, okay, so here's the thing, there's only 2 defendants left on the trial docket for next week, so I need to know something today.
My other issue, Mr. Gertz asked me to say this. He is set in Judge Templeton's court
Oh,
on a case, Austin
Yes,
Jones.
especially if
Been
that,
tried previously too.
and that's next week.
That's next week.
Yeah, I'm not sure that I should have taken that into consideration. So obviously that is a specially set case for Mr. Gertz over there. And we've done a protection order for him to get that case taken care of since it's an injury to a
I
child.
understood, Judge. I think we're very close to resolving this case. Still, notwithstanding the other case, I
Okay.
still would like to try to push this case to get resolved.
Sure. So here's what I'm
Like to talk
gonna
to
do.
victims.
So what I'm gonna do is just for a short time, take it off the trial docket, place it on a review in about 3 weeks. That gives you and Mr. Gertz time to visit with Mr. Batiste, Mr. Coleman time to visit with anybody he needs to visit with. And then if something gets worked out, we'll take care of it at that time in 3 weeks. If not, it'll go right back on the trial docket and we'll go from there.
Understood.
Sound good?
Yes, Judge.
Okay, you can go back with the bailiff.
Thank you.
Good morning. Are you Darius Derry? And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Derry, in cause number 26, DCCR.
Here's the contrast. After several defendants rejected plea deals, this defendant is taking the opposite route. Watch how carefully the judge confirms every detail, because once this plea is accepted, those rights and options largely disappear.
DCR 0234, you're charged with the state jail felony offense of burglary of a building from December 17th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Derry is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of burglary of a building. Sentence you in accordance with your agreement to a term of 100 days in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've already been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right. Good luck to you, sir. You can go back with the bailiff.
Okay.
In
Kevin,
just one hearing, we saw defendants make dramatically different choices rejecting deals, negotiating terms, and accepting guilt. The big question is, which decision was the smartest, and which could come back to haunt them later?